Welcome to Planet Lex, the podcast of Northwestern Pritzker School of Law, bringing it to you from Chicago, Illinois.
Hello, and welcome to Northwestern Law's Planet Lex. I'm your host, Vice Dean Jim Speta. Today, I'm thrilled to have with me Andy Koppelman, who's the John Paul Stevens Professor of Law and also Professor of Political Science here at Northwestern. Andy's scholarship focuses on the issues at the intersection of law and political philosophy, and he has published extensively on constitutional theory, theory of discrimination law, free speech, freedom of religion, and gay rights. Andy's a truly prolific writer. He's written more than 100 articles published in books and scholarly journals, and many more appearing in the opinion pages of news publications like the USA Today, Salon, the American Prospect, and the New Republic. Andy received Northwestern's university-wide Walder Award for Research Excellence in 2015, and in 2019, Andy was the inaugural recipient of the Hart Dworkin Award in Legal Philosophy from the Association of American Law Schools section on jurisprudence. Andy's books include The Tough Luck Constitution and the Assault on Healthcare Reform, and Defending American Religious Neutrality. Andy's latest book, Gay Rights versus Religious Liberty, The Unnecessary Conflict, was published in June, and you can buy it at all the places that you buy books. And you should. Andy, thanks again for being here.
Very happy to be here.
We're recording now about a week after the Supreme Court's decision in Bostock versus Clayton County, which was a very important decision right up the middle of your research. And in fact, you co-authored an amicus brief in that case. The court ruled in a 6-3 decision that the Civil Rights Act of 1964 protects LGBTQ employees from job discrimination. This question centered around Title VII of the Civil Rights Act, which prohibits discrimination against employees on the basis of race, color, religion, national origin, and sex. Can you break down the case for us a little bit and what the Supreme Court decided?
The case consolidated several different cases from the lower courts. A couple of them involved employees who alleged that they had been fired from their jobs for being gay. There was one employee who was fired from her job for being transgender. And the question in each case was whether the firing was discrimination on the basis of sex, because the statute says that there can't be discrimination based on sex. So that was what the court had to decide. Is it the case that if you fire someone for being gay or transgender, you are discriminating on the basis of sex?
Let me ask you, before the Supreme Court decided this case, what had been the state of the law in the lower courts?
The lower courts were split. Some of them held that discrimination on sexual orientation or transgender status was sex discrimination. Some decided that it was not. And part of the role of the Supreme Court is to resolve disputes among the Court of Appeals as to what American law is. Each Court of Appeals decides for itself, but if you don't resolve that, if the Supreme Court doesn't harmonize it, federal law is different in different parts of the country. And that's bad. We're one country.
Okay, so what did the Supreme Court do here?
The court held that whenever someone is discriminated against on the basis of sexual orientation or transgender status, that is discrimination on the basis of sex. The court basically followed a decision that they made way back in 1978 that held that sex discrimination meant, I'm quoting the language here, treatment of a person in a manner which but for the person's sex would be different. So it's pretty straightforward. An employee who dates women is homosexual only if that employee is female. So employer who fires lesbians does not discriminate against all employees who date women, only the female employees who date women. The court said, if being female is the reason why you were fired, if being female is the reason why you were discriminated against, even if there were other reasons, if it is the but-for cause, the thing without which the discrimination wouldn't have happened, then that's sex discrimination.
But let me unpack that a little bit, because when you were introducing the case, you said that some of the employees were fired for their sexual orientation or for their transgender status. How do we make the bridge between discrimination on the basis of sexual orientation or on the basis of gender status to what the statutory language is, which is discrimination on the basis of sex?
Well, so one of the cases involved a transgender woman who was fired after making the gender transition. She wanted to come to work dressed as a woman. The employer did not say that I'm not going to employ anyone who comes to work dressed as a woman. The employer just said males cannot come wearing a dress. That's sex discrimination.
This seems to me to follow some writings that were really pioneering at the time that you did in the context of gay marriage. In 1994, in the NYU Law Review, you wrote, "If Anne is allowed to marry Bob, but Charles can't, Charles is denied the right to marry Bob solely because Charles is a man." Is that the same logical structure of the court's holding here?
Yep, I'd actually made that argument even earlier in my student note in 1988 when I argued that laws that prohibited homosexual sex were sex discrimination because if a statute makes homosexual sex illegal, the sex of the defendant is one of the elements of the crime that the prosecutor has to prove in order to get a conviction. So I've always thought that this was fairly straightforward. Most of the work of defending the claim that anti-gay discrimination is sex discrimination consists of responding to counterarguments because the argument is pretty straightforward. We've already covered it. And there is a range of counterarguments. And so I've published several articles in this area, just trying to take up the counterarguments which keep on proliferating and trying to explain why they don't work. I think the deepest of the counterarguments is a sense that a lot of people have that these are just two different kinds of discrimination that have nothing to do with one another. I think that that's a mistake, and I think that it can be shown to be a mistake if you just reflect on ordinary experience. Most Americans learn in early high school that if you fail to conform to the norms associated with your sex, you will be deemed to be homosexual and you will be stigmatized as such, and you are taught that that is a bad thing to be. So this imposes gender norms on everybody. It's not just about gay people.
Given the connection between the criminality of homosexual sex, the gay marriage issue, and Title VII, and given that the Supreme Court in earlier cases had held that criminalizing homosexual sex was unconstitutional and upheld the right to gay marriage, why did this case divide the lower courts under Title VII?
What was distinctive about this case was that for the first time, the lower courts picked up on the sex discrimination argument. In some ways, it was harder to avoid in this case because you've got a statute that says no discrimination on the basis of sex. And so it's hard to avoid the conclusion that people are being treated in a way which would be different if they were a different sex. So I think that's why this was the area where it mattered.
The case not only had divided the lower courts before it reached the Supreme Court, it wasn't unanimous in the Supreme Court. And to me, at least, it had an interesting lineup of dividing the conservatives. In the majority, written by one of the conservatives, Justice Gorsuch, was also the Chief Justice, John Roberts, as well as the liberals, Breyer, Kagan, Ginsburg, and Sotomayor. But the other three conservatives dissented. What were the different reasonings of the dissenting opinions in disagreeing with the majority and then disagreeing with each other?
All of the judges who wrote were followers of a school of interpretation called textualism. The late Justice Scalia was its leader, and it proposes to ignore legislative history and just enforce the plain language of the laws. And if the language implies a result that the drafters didn't imagine, courts should follow the words rather than the unenacted intentions. Now, I'm not a fan of this approach to interpretation. I think that words taken out of context are more malleable than words in context a lot of the time, but this was a case where the words were so clear that I thought that you could really hold the textualists' feet to the fire and say, look, if you guys are going to follow this textual method, this is the only way that you can go with that textual method. And when we wrote our amicus brief in the case, we were very consciously targeting Chief Justice Roberts, who had expressed some sympathy for the sex discrimination argument in the past, and Justice Gorsuch, who is quite strict in his textualism, and we thought that both of them could be moved by this argument if we could show them that there's really no honest way out of this as the only sound textualist way to read the statute.
But as you say, the dissents are also textualist, at least in the way they state their own methodology, right?
The dissenters both try to avoid the literal language of the statute, and they try to say that this is nonetheless the public meaning of the statute at the time that it was enacted. And they follow different strategies. So let me go through them one at a time. Justice Alito said that at the time the law was enacted, if you look at dictionaries in 1964, you will find that no dictionary defines sex to include sexual orientation. He actually appended many pages of excerpts from dictionaries as an appendix to his opinion, and other statutes that used the word differently. And he thought that it followed that the statute didn't cover sexual orientation, that what the statute was about was equal treatment for men and women as groups, not individuals. The problem with this reading is that the statute doesn't refer to groups. Alito says in 1964, ordinary Americans reading the text of Title VII wouldn't have dreamed that discrimination because of sex meant discrimination because of sexual orientation, much less gender identity. But the act does make it actionable to treat a person worse because of her sex, and that is what the employers were doing in these cases. There's some ambiguity about what's meant by plain meaning. A lot of the time, it refers to prototypical meaning. Prototypical meaning is what comes to your mind when I say a word. If I use the word bird, you are going to think about an animal that can fly. And so when you talk about sex discrimination, people immediately think of discriminating against women because they're women and men because they're men. But plain meaning also refers to the definition of the word, all of the logical extensions of a word. And that's what courts generally do. They look at the statute and they ask, is it the case that this is covered by the language of the statute? So that's why courts have said that Title VII applies to sexual harassment or to refusing to employ mothers of small children, even though that's not the kind of discrimination that was first in the minds of people when they heard about sex discrimination. Ordinary language doesn't confine terms to their prototypical meaning. If otherwise, when I say bird, you're going to think of an animal that can fly, but ostriches and penguins still are birds. They're not the first thing you thought of, but you wouldn't want to say they're not birds.
So, and this is an important point, because one of the criticisms of the majority opinion, or at least one of the criticisms that has been made of the majority opinion, is that ignoring how the language would have been understood at the time that it was passed, or its prototypical meaning, to use your term, means that the statutory meaning actually changes over time.
No, I think that the statute always meant what it literally says. There is a question about changing social mores and what the role is of social change, but that's not inconsistent with social change helping us to see the literal meaning of a law. Sometimes prejudices are so deeply entrenched that everybody's mistaken about what the law actually is. So in 1896, in Plessy versus Ferguson, the Supreme Court upheld racial segregation. And that decision was so uncontroversial at the time that the newspapers barely noticed that it had happened. And those prejudices had to be overcome. Society had to change because before people could clearly understand what the Equal Protection Clause of the Constitution meant. So some people may not know this, but on the internet, you can find cute videos. And one of the cute videos you can find on the internet shows an infant getting its first glasses. The baby's confused at first, and then abruptly it smiles at the realization that it can see for the first time what was there all along. I think the relevant social change in this case is like that.
And so the relevant social change helps us to understand when certain behaviors are discrimination on the basis of sex and therefore have been illegal since 1964, even though we didn't understand
They always were discrimination on the basis of sex. People were being treated worse because they were male or because they were female. That's sex discrimination.
So you've been talking about the Alito dissent. What about the dissent by Justice Kavanaugh?
Justice Kavanaugh used a cleverer approach. In fact, the argument that Kavanaugh made was not made by any of the lower court opinions. There were splits in the lower court. He came up with it himself. And he said that when courts apply statutes, they generally follow not its literal meaning, but its ordinary meaning, the meaning that people ordinarily assign to the terms. There was a statute that gave people rights over certain mineral deposits. Somebody claimed that mineral deposits included water because water is a mineral. And the court said, no, that's not what was meant by mineral deposits. Anybody looking at the statute understood that it referred to solid minerals, not liquids, and certainly not water. And there were other cases like that, declined to hold that personnel rules encompassed any rules that a company had that personnel had to follow. It held that beans aren't seeds. It held that an aircraft isn't a vehicle. Buying drugs is not facilitating drug distribution. All of these were literally within the statute. And so Kavanaugh said, ordinary meaning sometimes means that you don't literally apply the statute's terms. The way that Justice Gorsuch responded to this was by saying, well, in all of those cases, an alternative account was offered of the language's meaning. So mineral deposits, we mean solid minerals in the earth, stones, gold, or liquid deposits, oil, but not water, things of value that are mined as saleable minerals. Gorsuch said, rather than suggest that the statutory language bears some other meaning, the employers in dissents merely suggest that because few expected today's result, we shouldn't admit that it follows from the text. And so Kavanaugh wasn't really offering an alternative reading of the statute. He didn't tell us what the ordinary meaning was. He just said, this can't possibly be the ordinary meaning. And so ordinary meaning gets filtered through whatever blind spots are shared by otherwise reasonable people. Now, this is not a good way to read any statute. And if you apply this to statutes that are aiming at broad social transformation, then this original cultural expectations move has a conservative bias. The tendency is to cabin and defeat the very laws that it's purporting to interpret. Normally, you read a law to give full effect to its purpose, but laws that are aiming to counteract prejudices, by their very nature, press against the background culture. And so if you take that background culture to limit the meaning of the law, that what was enacted as a broad principle is going to be pruned down to only its paradigmatic cases.
Let me ask you an unfair question, since you've identified Gorsuch's textualism and Alito's textualism and Kavanaugh's textualism, but you identified the late Justice Scalia as the father of textualism. How do you think Justice Scalia's version of textualism might have played out in this case?
When we were writing our amicus brief, we relied on Justice Scalia's textualism. Our view is that the kind of textualism that Justice Scalia offered supports the result that the court reached. Let me read you some passages from the writings of Justice Antonin Scalia. It is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. He said that in a case that held that same-sex sexual harassment was sex discrimination under Title VII. He said that courts should, I'll quote here, reject judicial speculation about both the drafter's extra-textually derived purposes and the desirability of the fair reading's anticipated consequences. And he said that if you disregard the unenacted intentions of the drafters, that will provide greater certainty in the law and hence greater predictability and greater respect for the rule of law. And he said this, and this is relevant in this case. In fact, this case was a test of this dictum of Justice Scalia. He said that this will curb, even reverse, the tendency of judges to imbue authoritative texts with their own policy preferences.
That seems to me to be quite relevant to what you were saying about Kavanaugh. And if Kavanaugh's resort to ordinary meaning is almost backdooring in the purpose of the legislature, because the purpose of the legislature should be understood in terms of what their ordinary meaning might have been at the time, as opposed to the text itself, which is what Scalia's lodestone seems to be in the quotes you've given.
Mm-hmm. I think that Gorsuch is more faithful to Scalia's method than Kavanaugh. I think that Kavanaugh is bringing the original expected applications into the meaning of the statute. To some extent, though, this is a broader problem with Scalia's method. It is very hard to understand statutes without attention to their broader purposes. And so it's hard not to think about that when you read a statute. Scalia's method demands that you not think about it. I think what happened was that Kavanaugh couldn't not think about it, and he had a view of the statute that didn't see the distinction between sexism and heterosexism. I think that the distinction is there. He didn't see that it was there, and he thought that he had to be shown that it was there. In fact, though, sex discrimination plaintiffs don't have to show that their disadvantages are part of a campaign to subordinate women. That would be a mighty heavy burden to put on plaintiffs, and Congress certainly did not put that burden on plaintiffs.
No, this comes back to the point you made that it's not a group-based statute. It's about the individual and the employment decision made with respect to that individual.
That is why I think Gorsuch has the better of the argument.
Let's look a little bit forward from Bostock. Just a few days before the Supreme Court issued its decision, the Trump administration announced that it was rolling back Obama-era healthcare protections for transgender individuals. In fact, the Department of Health and Human Services said that this was based on the plain meaning of the word sex as male or female and as determined by biology. What effect do you think the Bostock opinion has on this decision and similar decisions across the administrative state?
I have been told, I have not researched this, that the Obamacare statute in its prohibitions of discrimination incorporates Title VII by reference. And so if that's right, that would mean that the government's rules in this area have to be controlled by Title VII as it is interpreted by the Supreme Court. Since the Supreme Court has now said that discrimination against LGBT people is sex discrimination, that would necessarily carry over to the Obamacare statute. And if that's right, this regulation of the Trump administration will not survive in court.
This interpretation of discrimination on the basis of sex should be broader than just Title VII, right? It should apply to Title VI and Title IX and other federal anti-discrimination statutes, shouldn't it?
It should, and courts in interpreting the various provisions of the statute are influenced by guidance from the Supreme Court about the meaning of Title VII. These various provisions tend to be read together.
Another issue for the future that will arise out of Bostock is the question of exemptions from its rule and the rules of Title VII for religious organizations. And this is a topic at the center of your new book, Gay Rights versus Religious Liberty, The Unnecessary Conflict. The agenda of that book seems to try to offer a path to end what you see as an unnecessary clash between gay rights advocates and conservative Christians. Why don't you describe the argument that you're trying to put forward in the book?
So, this conflict, which really does center around the question of exemptions from anti-discrimination law, has to do with the consequences either of having anti-discrimination law in the first place or of granting exemptions from it. And one of the things that I learned in working on the book is that there are people on both sides who are very frightened. Gay people are afraid of that any religious accommodation is going to unleash a wave of discrimination against them. And religious conservatives, which is a crude term that I'm going to use to refer to people who believe on religious grounds that homosexual sex is never morally appropriate. They are afraid that they're going to be driven to the margins of society and to be treated as badly as racists are. I think that it's possible for people to radically disagree about these things and still have a safe space in our society. The whole idea of religious toleration is that people live together peacefully, even though they think their neighbors are radically mistaken about the meaning of life and ought to live entirely different lives than they're living. That's just what happens in a free society. We radically disagree. The other thing that I get into in the book, which is quite relevant in the context of the Bostock case, is what the purposes of anti-discrimination law are and whether those purposes will be defeated if there's religious accommodation. Because this is a question that we've had every time we've been presented with a claim for religious accommodation. And those claims go back to before the founding of the country. Even in colonial times, there were Quakers who wanted to be exempted from military draft. Courts were held on Saturdays, and Jews would not come in and testify on Saturdays. Catholic priests were unwilling to testify to what they'd learned in confession. And in those cases, there was a general tendency to accommodate, really when you could accommodate the religious dissenters without defeating the purposes of the law. And so I think that's really your question here. Is it possible to have religious accommodations if you have a baker who is not willing to make a cake for a same-sex wedding? How bad would it be if you accommodated him and told people to go to a different bakery? My own view, given the way that American culture has changed, is that you're just not going to get an awful lot of these accommodation claims. And so it's possible to have an accommodation without defeating the purposes of the law.
So operationalize that for me in this context. What would be the scope of a reasonable accommodation to the decision here on Title VII?
Well, the accommodation that matters here is actually already in Title VII, because Title VII already has a provision that permits religious associations and corporations and educational institutions and societies to discriminate based on religion in a whole range of ways that other entities can't. And it defines religion to include, I'm quoting from the statute here, all aspects of religious observance and practice as well as belief. So that, I think, pretty clearly means that, for example, a religious school that wants to have no employees at the school who are openly gay and who are engaged in behavior that their religion teaches is morally illicit, they don't want to have any employees like that. It does impair the educational mission. As I read Title VII, they already have that right. So there is a religious accommodation already in the statute. With respect to little bakeries like the facts that I was describing before were the facts of Masterpiece Cake Shop versus Colorado, which the court decided a couple of years ago, involved a fairly small bakery. The statute, the Civil Rights Act of 1964, only applies to employers of 15 or more employees, so probably wouldn't apply to that bakery anyway.
As we're looking forward into the future of these issues, what are you working on next?
I'm writing a book about libertarianism. It struck me as a really weird way of looking at the world, and I also have a PhD in political philosophy. I spend a lot of my time looking at weird ways of looking at the world, and I find them fascinating. And so what I've found is that this began in the 1940s as an admirable attempt to argue against central economic planning. And it has turned into an idea that is quite strong, particularly in the contemporary Republican Party, that anything that reduces the power of the state is good. This then brings together a coalition of two groups. One is principled libertarians who really believe that human freedom is maximized by limiting the power of the state, and the other is people who'd like to be able to hurt other people without being bothered by the police, of which a preeminent example is the fossil fuels industry, who use libertarian rhetoric in order to facilitate their work in warming up the planet and destroying our environment.
Wow, that's a really, really broad-ranging project. Does it connect at all to the work that you've done? I know it does. Tell us how it connects to the work that you've been doing on gay rights, where there's both an issue of libertarianism, but the state is involved in these rights protections that we've been talking about.
Well, I'm a liberal. I want to have a society in which people have the freedom to be weird in whatever way they want to be able to live their lives as they like, and to do it in security. What I am trying to do in the Gay Rights, Religious Liberty book is show a path for these very different groups to live together and to find a place for themselves in America. Libertarianism is a mutated version of liberalism that uses liberal rhetoric, I believe, to illiberal ends.
Well, I'll be very much looking forward to that coming out. Before we go today, let me mention another outlet where you can find Andy frequently writing in real time on these and other issues of constitutional law and theory, and that's the Balkanization blog at balkan.blogspot.com. Andy, thanks for joining me today. That's our show. If you like what you heard, please subscribe and rate us on Apple Podcasts. Thank you for listening. I'm Jim Speta, signing off.
If you'd like more information about today's show, please visit law.northwestern.edu/planetlex or LegalTalkNetwork.com. Subscribe via iTunes and RSS. Find both Northwestern Pritzker School of Law and Legal Talk Network on Twitter, Facebook, and LinkedIn. Or download the free app from Legal Talk Network in Google Play and iTunes. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by, Northwestern University, Legal Talk Network, or their respective officers, directors, employees, agents, representatives, shareholders, and subsidiaries. None of the content should be considered legal advice. As always, consult a lawyer.